Don't say anything, it'll be completely gone.
Hi, everyone. I am Leah Nyland, antitrust journalist, formerly of Politico, soon to be of Bloomberg, currently unemployed. We are going to talk today a little bit about antitrust in labor markets. We are going to leave plenty of time at the end for questions. I'm also happy to take questions on Twitter from folks who are watching on the live stream, so feel free. I've started a Twitter thread. You can DM me or post a question there. But we're going to have Jan sort of start us out.
Thank you. I have a couple of slides. Thank you very much for the invitation to talk here. So I'm going to do something slightly different. You know, I'm realizing that there's a lot of experts here in the room who know a lot about the antitrust, and it's going to be somewhat disappointing what I'm going to show you because I won't have answer to the big question of the conference today, what's next. In fact, what I think I'll be doing is I'm going to add more questions or problems to address. But I hope it's relevant for thinking about the role of labor markets. So I'm going to show you three graphs to try and illustrate what this is about. And by the way, I also hope that it addresses Thomas's question that he raised earlier this morning, which is that we should focus on the big issues and not on the exceptional cases that we often as academics tend to. Now, I'm going to start with one fact, which is to try and illustrate what has happened economy-wide to market power. And this is very different from what we typically do when we look at a particular case, because then there's an argument about, you know, is there, maybe we look at concentration ratios, maybe we look at other kind of measures that tell us something about a particular market or even one individual firm. I'm going to try and make a statement about the economy as a whole, and this is, you know, probably going to be too broad brush to be sure what it is. And there's a lot about discussion about what these data tell us. So I can show you 15 different series that tell us similar things, and there's debates about what each series represents, how relevant or how representative it is about the whole economy. I've chosen a series here of the Dow Jones. Okay, so I'm going to show you the Dow Jones since the Second World War. Now, it's not the Dow Jones that you see when you just go to Wikipedia or you go down to any of the finance sites and you want to see the series, long time series. It's the Dow Jones adjusted for inflation, which I think as economists we think we should do. And this series, like any of my other 15 series, I would show about what happens to market power is going to have issues. You know, there's share buybacks in the late 90s, 2000s. But I just want to show this series, and what happened to the Dow Jones starting in this, after the Second World War is basically that you see an evolution that until the 1980s, the Dow Jones was fairly flat. In fact, in 1981, the value of the Dow Jones was exactly the same as the one when my series started. I think it's in 48. Okay? But then something changes. And what changes is that we see that the Dow Jones, adjusted for inflation, starts rising dramatically. Now, the question is, what does this measure? Well, as economists would say, the stock market value of a firm is the discounted stream of dividends profits. Okay? And so it gives you basically what the valuation is of a firm for one individual firm, okay, at this point, or what people expect it will be. Now, the Dow Jones is only 30 firms, okay, and this is part of the narrative that I want to convince you of. There's only 30 firms, but what this is saying is that profits of the largest 30 firms, by the way, they're not the same ones because they change, but the profits of the largest 30 firms have started to increase dramatically since 1980. I can show you markups, I can show you profit rates, I can show you different measures that tell us the same story. 1980 is a kind of a turning point. Okay. Now, we're here to talk about the labor market. What I want to show you next is that this has consequences. The consequence that this is having is that I'm going to show you now a series from, I think it's 48 also in this case, from 1948 onwards that says, what is the evolution of the productivity in the economy? And this is, for the economists here, just labor productivity, so it's GDP per worker, relative to wages. Now, what I'm going to show you, I'm going to cheat a little bit, but that's part of the point again. This is going to be wages for 90% of the working population. It's going to be for those who do production and service jobs. Okay? So our CEOs and managers are not in there. It's basically the people who are not doing supervisory jobs. Okay? What has happened to that? Well, you see that evolution until 1980 is going in lockstep, and then in 1980 we see wage stagnation, and we talk about wage stagnation quite a bit. Okay. And then the last figure, the third figure, which is going to be related, is the following. I'm going to show you what happened to startups. Okay. And so the way we measure startups, I use kind of typical measure that Wenger uses, but we can talk about again how we're going to measure it. And this is the percentage of basically new firms. It used to be just under 14% in the late 70s. What has happened is that these startups, they basically declined to around 8%. Okay? This is probably the most shocking fact, because I've tried it, if you go to a kind of a cocktail party and you try and say something interesting as an economist, you say, this is the digital age, but there's fewer startups today than there were in 1980. It's just like, I mean, what kind of economist are you? We can measure it many different ways. This is a very robust fact. It's actually true also in Silicon Valley, by the way. People say, yeah, but it's not true in Silicon Valley. Silicon Valley has also declined in the number of startups. There's a whole debate about what's going on. What we're finding is that there's this close relationship. The reason, by the way, even though this is a panel about labor and about the labor impact or the impact on work of market power, the reason why I put this up is because what we find is that on the one hand, I showed you, yeah, market power has gone up, however we measure it. It might not be exactly the same how people who do consulting find it, and they say, you know, I see this case, I haven't seen market go up. What our measures all say since 1980, it's going up economy-wide. And the point is that this has macroeconomic implications on the labor market, on wages, there's wage stagnation, on small firms, on startups. It has also different effects on migration, on mobility. It is a whole number of effects. I could only use 3 slides here, so I showed you these 3. Now, the thing is that, and this is, I think, the challenge for antitrust, or it's probably more ex-ante regulation than antitrust, is that this is not what Johan is going to be talking about, which is monopsony power. That is, you know, the big Toyota factory in Alabama that is paying lower wages to its workers because these workers can only work for that one big Toyota factory. They can't go somewhere else. This is different. This is because there's maybe one of the tech companies, but also Inditex in Europe. There's a Japanese company. There's AB InBev, the beer brewer. There's basically about 400 or 500 global firms that have a dominant position. They're large. They're probably about 30 to 40% of GDP of their markets. And that has equilibrium effects. I'm not allowed to use this, but they have kind of, you know, no lingo in that sense, but that has equilibrium effects through what? Well, these firms, they price above cost. So they sell fewer units. They make higher revenue, no doubt about that. They do it for higher revenue, but they sell fewer units. So basically the number of units that they produce or need to produce is going to be lower, and therefore the demand for labor is going to be lower. So it's not Google that pays its workers badly. It's the indirect effect, a pecuniary externality, just like pollution is a pecuniary externality. This indirect effect that it has on the labor market as a whole, and it's not just the labor market, it's the startup market. It's the mobility market. It has a whole number of economy-wide effects. Okay? And that's kind of the link between output market power and the labor market. Again, I want to stress this is different from what Joanna is going to talk about, which is the direct effect of one firm on its workers. Okay? And that's on top of what's going on here. We find that this has large welfare implications. And I think the challenge again is for antitrust. How do we measure this? This is the same legal problem as, and this is someone who has no idea about legal problems, but this is the same legal problem as dealing with CO2 emissions and how this affects, you know, asthma in people. I can go and talk to someone and say, you know, I get asthma, or my grandmother get asthma and she suffers from it. I can't go to someone and say it's because of your car. No, it's because of the 8 billion cars in the world that are causing this, and our heating systems and everything together. And it's the same here. We can't say it's because of Google that the wage of the server in a restaurant has stagnated. It's because Google and all these other firms together. And that's this pecuniary externality. And so this is, again, my challenge to the legal profession and the antitrust enforcement profession, more than answering questions, adding one more, how can we deal with this? I should say that the cost is large. We find when we model it, we didn't do it with inviting people to come and talk to us, as Jonathan was suggesting that they want to now do. We do it with the old-fashioned way, with a model. But we find that the social cost is large, between 8 and 10% of GDP. Okay. If you look at, and I like to make that comparison with the cost of inflation. The cost of inflation, famously estimated by Bob Lucas, is about 0.5%. We spend around, in the United States, around $6 billion on the Federal Reserve System, which is controlling inflation plus banking regulation, really. Right? What we spend on antitrust is a lot lower. I think Bill this morning was saying we should have $1 billion on antitrust. That would still be 1/6. And even if it would be 1/6, remember, the cost is 8 to 10% instead of 0.5%. So I would just advocate that we should spend a lot more on enforcing competition in markets. Thanks.
Ayana.
All right. So that's a great introduction to what I'm going to talk about. So as Jan just has shown, we've seen wage stagnation for workers, and that has prompted growing interest in policy solutions to this issue. And when you look at this issue from the point of view of labor economics, you would hear a lot of things like the race between education and technology, that maybe workers don't have the right education to be competitive, and therefore they are not skilled enough. But note that this whole line of reasoning presumes that workers' wages perfectly reflect their skills. And that's something that I've been interested in better understanding. Sure, skills matter, but it could be the case that workers are underpaid due to, importantly, a lack of competition in the labor market among employers, so that you could have a wage markdown. Just like you have a price markup when you have a lack of competition in the product market, you're going to have a wage markdown when you have a lack of competition in the labor market. And so one approach to try to evaluate that is to look at competition for workers concretely in the labor market. We have this big data from an online job search platform. So we really see for a particular worker how many potential jobs they could be looking at. And that allows us, using standard I/O models to show that jobs are highly differentiated, meaning that for any worker, there are some jobs that are way preferred to the alternatives. And we show one big reason for that is simply distance from the worker's home. The worker prefers, all other things equal, a job closer to home, so they're not going to easily substitute to another job that is going to be further away. And so we showed that, if you go through these empirical estimates and you use a model to put that in perspective, this creates market power because jobs are differentiated and would allow employers to underpay workers relative to their marginal productivity. And we find a wage markdown of about 20%, meaning that workers on average are about 20% more productive than the wages that they get paid. So that's one approach to understanding this phenomenon of how a lack of competition in the labor market affects wages. Another way to measure competition is by looking at concentration, which is well known in antitrust, but instead of looking at concentration of sales, we're going to look at concentration of employment, and more specifically, we use, again, this data set from online job platforms, and we can see, and by the way, these are real jobs. These are not like Amazon Mechanical Turk. It's just actual advertisements for actual job in the real world. Some might be, online, but, this is regular kinds of jobs. And so using this data set, which here we have essentially all jobs in the US, we can show that the majority of US labor markets, or 60%, are highly concentrated if you use the standards of the horizontal merger guidelines. So concentration is above 2,500, meaning that there's fewer than the equivalent of 4 equal size employers who are competing for workers at any given point in time. And so This we also show in other work that higher labor market concentration tends to lower wages for workers. So as this concentration in a given market increases, workers' wages tend to decrease. And there are some ways to look at this also in a very policy-relevant way for antitrust, which is to focus on mergers. And there are 2 papers by Prager and Schmidt and by Arnold looking at mergers and how they affect wages as a function of labor market concentration. So essentially, you expect a merger that occurs in a highly concentrated market where we have a competition problem to really lower wages, while a merger that occurs in a very competitive labor market may not have much of a wage effect. And that's in fact exactly what these 2 papers found, that only mergers that significantly increase concentration in a concentrated labor market, and mind you, I'm talking about labor market concentration, the concentration of employment, not the concentration of sales, that such mergers, again, that increase concentrations, are those that reduce workers' wages. And so, you might think, oh, maybe it's not concentration, maybe it's something else. And the papers really do a great job looking at that. But another way that I validate this with my own research is, I started with saying a lot of the literature presumes that workers surely must be paid exactly their productivity. And that's one of the arguments why you might think that increasing the minimum wage is going to lower employment. Because that would mean if the workers are exactly paid their productivity and you demand that employers pay them more than their productivity, the employer is just going to let the worker go. So you expect the minimum wage to reduce employment. But what we see is that the minimum wage, yeah, it does reduce employment in the very competitive labor markets as measured by low concentration, but it actually increases employment in the less competitive labor markets where workers' wages are significantly below their level of productivity. And so that's another way of validating the approach that concentration is a good proxy for the amount of competition in a given labor market. And so having acknowledged then that labor markets in many ways are just like product markets, they are subject to market power, and maybe arguably for a number of reasons, maybe to even more market power, but certainly they're not unique. There's market power in labor markets as well. Then, we should think about how antitrust can address this issue. And so far, there's been, until recently, very little enforcement, which means that, addressing this issue could have really high returns since we're starting from, very low enforcement, doing a little bit more, surely, must have a lot of returns in terms of improving competition in the labor market, which ultimately will increase wages and thereby, help address the issue of wage stagnation that we started with. So,
Great. Eric.
Okay, I have a slide, just one slide, so it seems a little silly to have to walk all the way up here just to show you one slide, but thank you. We're done. There it is. Okay, so Jonathan Cantor outed me at lunch, so I have to say that my views are not necessarily those of the Justice Department. In fact, this graph I made, a while ago, and this is a lawyer's empirical study, by the way. I have just numbers here, and what they show are over the last 3 years or so, last 3 or 4 years, the number of antitrust cases involving the kind of typical scenario of sellers getting together and raising prices. Okay, so output or product market cases, versus the number of cases involving labor markets where employers get together to suppress wages. And the blue lines are the product market cases, and the orange lines are the labor market cases, and it's just divided up by different sections of the antitrust law. So this is Section 1 of the Sherman Act, meaning collusion. Section 2 means monopoly, or in the case of labor, monopsony. And this is Section 7 of the Clayton Act, and that refers to merger review. And so, for example, this actually would probably be 0. There's some argument about whether there was 1 or 2 merger reviews that looked at labor markets versus hundreds that looked at the product market effects of mergers. So there's this enormous gap between, and this goes back throughout the history of antitrust law in the United States, there's an enormous gap between using antitrust law to challenge sellers who engage in anti-competitive behavior to raise prices, lots of that, versus using antitrust law to challenge employers who suppress wages. Very little of that. Of course, these are the same companies. So just imagine, for example, a manufacturing company that has factories all over the country. It merges with another manufacturing company. The antitrust community would look at this and say, well, is it going to raise prices of the products that they manufacture? Are those the only two companies that manufacture that product? Is that product market concentrated? What historically has never been done is to look at the labor market effects. So if, for example, those two manufacturing companies have factories that are in the same town or the same commuting zone, it's very possible that the merger could result in increased concentration in a labor market, which would enable the merged firm to suppress wages. Now, this graph is just supposed to raise a question. Why is there this litigation gap between labor side and product side antitrust? And there are a number of possible answers. The first answer is that antitrust law only applies to product markets and prices and behavior that affects consumers, and it doesn't apply to labor markets and behavior that affects workers. That's clearly not true. The antitrust statutes don't make a distinction between markets. They apply to all markets. And the Supreme Court recognized as early as the 1920s that labor market cases are covered by the antitrust law. There's a case from the 1920s involving a bunch of sailors who were trying to work for different ship owners, and the ship owners combined to suppress their wages. And the Supreme Court had no problem recognizing that as a valid antitrust claim. Another possibility is, well, maybe labor markets are covered by antitrust law, but we really don't mind so much if firms engage in collusion, if they suppress wages, whereas we do mind if they raise prices. And some people will say, and in fact, courts have said this, it's actually good to suppress wages. That means labor costs are low, and the savings will be passed on in the form of lower prices for consumers, okay? So that's not good economics. And it forgets the fact that workers and consumers are the same people. So if you have high prices, given a wage, that's bad if prices go up. But it's exactly the same if your wage goes down while prices remain the same, right? You're worse off in both situations. Labor market monopsony normally will reduce output because the employer, in order to save money, hires fewer people. And that would normally, although not unavoidably, result in higher rather than lower prices. Another possibility is, well, this just doesn't happen very much. Okay, so collusion is actually quite rare among employers. And, sure, there are these mergers all the time, but these are big national companies. Labor markets are almost always local. Surely the effect of these mergers aren't going to increase the concentration of labor markets. Now, the first person who objected to this line of reasoning was Adam Smith, who said in The Wealth of Nations that employers, well, masters in those days, but employers, they're always colluding. That's just what they do. People complain when workers collude, which means forming unions. Then there's a great hue and cry. But nobody really cares. Everybody understands this is what employers do. He thought that was bad because he was in favor of free markets. He thought that was just as bad as product market collusion, which he also criticized and thought was quite common. But he's not the only person who's made this point. If you just look at the recent research by people like Joanna and many other economists, we find out a couple things. So first of all, this kind of well-known paper by Ashenfelter and Kruger showed that around 50% of the big brand name fast food franchises use no poach clauses in their franchise. So that meant that if you worked at McDonald's and you quit, you weren't permitted to go and work at a competing McDonald's. If they tried to, for example, lure you away with higher wages. And work by Evan Starr and multiple co-authors show that covenants not to compete, which prohibit a worker from going to work for a competitor of his or her employer after she quits, or even starting his own business that would compete with the former employer. Those non-competes are extremely common and often imposed on low-wage workers, low-skill workers. So there are tens of millions of people covered by these non-competes, which reduce competition in labor markets. And then the work by Joanna and her colleagues and other people would show that labor markets are highly concentrated around the country. It's kind of hard to compare, product markets and labor markets, but there's no particular reason to think that concentration is more of a problem in product markets than in labor markets. Concentration is ubiquitous in both types of markets. Now, concentration by itself is not an antitrust violation, but if markets are concentrated, then we have to worry about mergers that take place in them, and we have to worry about whether the monopsonists in those markets are using their labor market power to extend their labor market power, or for that matter, product market power into other areas of the economy. There's a very famous case which I think kicked off the concern about labor monopsony, which was the 2010 Silicon Valley poach case. This involved Google, Apple, Pixar, and other major Silicon Valley companies. They agreed not to solicit each other's software engineers. They just did that, and the emails are there. The Justice Department obtained their emails. You can read them. They're online if you're curious. That's a blatant antitrust violation, and that was one of the first cases in which the government got involved in trying to address labor market antitrust problem. So it's probably not the case that they're rare. In fact, as I think Joanna was alluding to before, if CEOs are looking around and they know that the government and private plaintiffs are keeping an eye out for possible product market collusion, but they still want to make above market returns, the rational thing for them to do is to go and look at what's going on in the labor markets and extend their market power in those markets which are not being looked at. There are some other possible explanations. Let me just focus on one, which I think might be two, and then I'll stop. So one is a kind of a path dependency argument. In the old days, the idea was that for labor markets, the law would provide two sources of protection for workers. The first is labor law, which would support unions, so as to prevent employers from using underhanded tactics to prevent workers from organizing. And the other is what lawyers call employment law, which you can think of as the minimum wage and various safety and health rules. Union organization in the United States peaked in the 1950s, and now it's a very tiny fraction of the workforce is covered by unions. So they are no longer providing the protection for workers that they once did. Employment law still exists, but of course the minimum wage law has been stagnating. And in any event, the minimum wage law is not, whatever it's set at, it's not going to make much of a difference when we're talking about labor market concentration throughout the economy and not just at the bottom. I think economics has played a big role in this because, at least in the old days, it was understood that unions and employment law would take care of the problems of employer labor power. Antitrust should focus on product markets, and so the economists naturally, would write models and do research relating to product markets, and they kind of forgot about labor markets. Now, there are labor economists who wrote about labor markets, but they weren't focused on market structure. So there was this kind of bifurcation between IO economists talking about product markets. They, of course, knew about labor markets, but their general assumption was that labor markets are efficient or reasonably competitive, and so it wasn't an antitrust problem. So this division of intellectual labor has probably contributed to the absence of a lot of antitrust litigation directed at labor markets. Okay, fortunately this is changing. Some of the credit goes to the government for waking up to this problem, going back to 2010. a lot of the credit go to economists like Joanna, who have, and Evan Starr and the other people I've mentioned who have brought to light these problems in labor markets. And so I think going forward, this litigation gap will close at least a little bit. I don't know how far it will go. The last remaining barrier, I think, now that people are more informed about this problem, is probably the judiciary. These cases are novel. They're kind of hard to understand. There aren't a lot of precedents. So it may be difficult for judges to deal with them in the proper way, but it's too soon to tell. And with that, I will stop.
Okay, I thought I would. It's a bit humbling. These are the Hall of Famers of these topics here on this panel. I thought I'd just make 3 quick points. I think I'll be under the time, and we can engage in dialogue. The first point I'd say is you've gotten a flavor of some of the research. I would say that the last 15 years, there's been a sea change in the belief of economists documenting the degree of market power in the labor market. That 15 years ago, if you just asked a typical economist, they would have thought there was close to zero monopsony power, that everybody's just paid their marginal product and that's how it is. The 3 sources of monopsony power, one is concentration that the Marinescu et al. Have documented. 2 is differentiated jobs, and 3 is search frictions of some other kind. And those are kind of the 3 big sources in the literature of where market power comes from. I raise that because some of those aren't exactly the same as on the product market, so that might partly explain the some of the case gap that Eric described. And Eric's got a fabulous book that's fascinating and provocative on this question of did antitrust fail, and in a sense, is this market power in the labor markets, is it caused by antitrust? My own small contribution in this area with another professor, we looked at the labor markets in higher education for faculty, and the basic idea of market power is if it's a free market in the labor market, if holding everything else equal, if they cut your wage by 1 cent, you should leave. And to any extent that you don't, they have the employer faces not, they're not a price taker on wages, and so they would probably take that into account and decide how much employment to do, weighed off against driving up the wages. We looked at professors, which is a slightly unusual case in that most of the concentration studies are about local labor markets, which are kind of often lower skilled jobs where the competition is local. Professors, it's a national market, it's a high skilled job. If you look at measures of concentration, they're extremely low. No one university dominates the labor market. We were able to show that universities look to have a fair degree of market power, probably, we think, mostly coming from the differentiation of the jobs, that if you get tenure and you're a good fit to the University of Chicago and you move here and then for whatever reason Chicago cut your wage or stopped growing, you wouldn't just say, that's it, 10 cents less, I'm done, I'm going somewhere else. Though there's a bit of a cautionary tale, if you're a person who believes it comes from concentration, there's very little evidence in this market that concentration matters. So in a sense, you would look at it and say, very low concentration, there must not be monopsony power, but we documented there was, and it affects the business. So we say that as the scale of universities expanded and they started enrolling more people, so they had to hire more faculty, the fact that they have monopsony power over the tenure track faculty and they look to be wage takers in the market for adjuncts pushes them to, there's been a huge rise of adjunct faculty in the US, and our argument is one part of that is monopsony, that as they know they got to get bigger and take more students, they naturally shy away from the tenure track faculty because to hire more of them would drive up the wages. You know, mostly our, the interest of other faculty in our findings would seem to be highly correlated with us saying, you might be getting paid up to 40% less than your marginal product. They were like, wait, what? We're underpaid? You know, so category one is a lot of documentation that there is market power in the labor market coming from one of those three categories. Leads me to category two, my second point, which is I'm a little uneasy about blaming that market power on antitrust, that it's antitrust that failed and caused it. The specific behaviors like non-compete clauses, in a way, go into the category like in the product market of collusion, where it's just prima facie, it's against the law, and so you should block them. You don't have to prove that it's good or it's bad. My cautions are, I do feel like we need to think harder about the interactions of the product market with the labor market. And so this characterization that some of the judges say, well, maybe it's good if wages are pushed down because that would translate into lower prices, they can't be totally dismissed out of hand. Otherwise, you would turn antitrust into the new protectionism. And that is to say, the essence of the argument when you say, why are tariffs bad, is fundamentally that the wages save, you put in tariffs, you save some jobs, that if you add up all the wages saved of the jobs preserved, they add up to far less than the damage of higher prices on the consumers. I do think as we think through the antitrust application of these ideas, we want to think through issues where if we did this and we're able to raise wages, but that had a negative impact on consumers, there at least got to be some balancing out. And the fact that we have developed maybe it's a common law, we've developed some intuitions about concentration, whether it's measures of Herfindahl index or when is it a danger. And I don't think we really have the intuition of should the same numbers apply to job markets. So like in the higher ed context, they don't. It is, here we document market power, but if you just applied the normal antitrust rules and said, let's just apply the merger guideline type rules to labor markets, you would in no way say that there was any danger of market power whatsoever. The last thing I'll say about that is I also want everybody to emphasize an obvious point that this is not the same thing as income distribution. Okay, so if you have a merger case of two yacht makers, there is one argument that could say, well, wait, shouldn't we think about the workers who are making the yachts? They're a lot lower income than the purchasers of the yachts. So if prices go up, is it really that bad if we preserve their wages? That's a different thing than are people being paid less than their marginal product. I think the creative industries is one where we're also going to want to think through these issues of if you could pinch the creators of TV video content, is that good or is that bad in the end for consumers? And the last thought I'll leave you with is whether COVID fundamentally changes the nature of market power in antitrust. a whole bunch of jobs shifting to online. On one argument would be that decreases the monopsony power of the employers because it's making what previously were local markets national markets. There is the other argument that it suppresses wages. Alan Blinder has made this argument. Well, once you open the labor markets up to the whole world, there could be mass displacement. You could see a increase of the profit share and a decrease of the labor share, kind of what Jan was describing. That's what I.
Great. Well, thank you guys so much for those sort of opening remarks. I want to pick up on a couple threads in things that people have said. I mean, Austin just said he doesn't think antitrust is necessarily responsible for this. Eric has written an entire book about why it is sort of responsible for all of this. But I mean, how much do you think antitrust can play a part in correcting this?
So if I can say, you can speak afterwards, but I think at some level, as far as policy prescription, it doesn't matter if antitrust did it or didn't do it. What matters is, will antitrust help now? And my contention would be that it would. No matter if it is the responsible, maybe it's a small effect, we can argue about that. But what is pretty clear, I think, is that strengthening labor antitrust enforcement is going to increase wages, and is consistent with the intention of the law, and therefore there's good reasons to do it. That's that. So.
Yeah. If I can also jump in, I do want to clarify some things because I disagree with some things that Austin. I agree with some things that Austin says, though he thinks I don't. So I don't want to be clear about where we agree. So first of all, I wrote another paper with an economist in where we tried to figure out how much of the wage markdown is due to concentration versus other sources of friction. And it probably is the case that most of these other sources of friction are responsible for wage suppression. There's only so much that concentration is going to add or subtract from people's wages. But it really doesn't have anything to do with the question of whether antitrust law should be used in labor markets, because we do know there's a lot of concentration. We don't know exactly yet whether the HHI should be different for labor cases than product market cases. But clearly there should be more than 0 merger reviews when firms merge and they have plants or other work sites in the same labor market. There's no justification, even if you think that the contribution of concentration to lower wages is relatively small. It's still a wrong being committed, and it's harming lots of people. I don't think, when I say antitrust failed workers, it's the title of my book. The title of my book isn't, the reason why workers are paid, 40% less than they should be is because antitrust law hasn't been used. That's not my claim. My claim is that antitrust law could do some good, but hasn't, for kind of these odd historical reasons that don't make any sense. And then the final point I want to make is that Austin and I think others think that the justification for using antitrust law in labor markets is to redistribute wealth from consumers to workers. And that's not my argument. It is an argument that one could make. The problem, of course, is that workers and consumers are the same people. And so it's not clear that this type of method for redistributing wealth makes any sense. If you used antitrust law more vigorously to promote market competition in labor markets, that produces more output. It produces a larger social surplus. To the extent there's any kind of redistribution, it'll be mainly from investors, holders of capital, to workers/consumers. And so on your graph, if antitrust law had been enforced, there'd be a little tiny downward trend in the stock market, in the Dow Jones index, which would be good because it would be offset by a larger increase in labor's share of economic output.
Can I just add one thing? I mean, for the other type of wage effect, the indirect wage effect, it's obvious that antitrust is going to help because antitrust in the output market, not in the labor market. Because the indirect effect is therefore going to basically increase labor demand and therefore wages. And that's going to be a direct effect in the sense that it's going to have this direct effect on wages.
It goes both directions, doesn't it? So if you use antitrust law in labor markets, and as a result, wages go up, and
Output
also,
expands.
People will buy more things in the product markets, and so everybody's better off.
Sure, but the point is that the indirect effect is there even if labor markets are competitive. So it's clear that you have to tackle both problems. But suppose that you had tackled the monopsony problem completely, and there is a monopoly problem or an oligopoly problem economy-wide, then you still have wages that are going to be below, because the purchasing power is too low. I mean, I'm not saying anything new here. I mean, everyone knows this. But the point is that antitrust in output markets is going to address this.
And just to clarify, what I should have said, I knew I was not alleging that Eric is taking the income redistribution point. There are people who say the reason that antitrust should address labor market monopsony is to help low-income people. That one I think is a little more complicated. I still think this issue of the interaction of prices and wages it's not enough. It's a little too oversimplified to say, well, the workers are the consumers, therefore anything that raises their wages is good for consumers. That's kind of what I was calling the protectionism argument, that you got to add up what's happening to the consumers as a whole and what's happening to the wages as a whole, and a lot of times one would be a lot bigger than the other. And so it would, logically, you could say antitrust failed by preventing some merger that would have raised prices, but there's rent sharing in this industry. And so when they raised prices and had more profit, they would pay the workers more, so we should let the merger go through. I kind of think that would be a inverted version of what I'm saying, that you want to think through the two against each other, and I would think you agree with that.
You want to go both directions.
Yeah.
I mean, I guess it's the difference between the consumer surplus and that similar area and the aggregate labor supplies function.
Yes.
I mean, it's you generate deadweight loss.
Yes.
In both cases. The difference is one is on the consumer side, on the demand side, one is on the labor supply side.
I'd like to pick up on one other thing. Did you have something you wanted to add?
No, go ahead.
Okay. On one other thing that Austin said right at the end is, the past 2 years of COVID have very much changed the labor market. How do you think that fits at all in with this analysis and what the Justice Department or the FTC should be thinking about going forward?
So anecdotally, I was fascinated by the fact that I don't know if it's Twitter or some other online company allowed workers to work from home, and then they said, you know what, you moved to Denver, we're going to cut your wages because the cost of living in Denver,
It was Facebook.
Okay, Facebook, thank you, is not as high. Well, assuming, and this is an assumption, that the productivity of workers work from home or in the office for such a tech company is the same, that's an assumption that we can debate, but let's say that that's the case, then the fact that the company is able to go through with this and cut workers' wages is a demonstration of monopsony power in the sense that the workers are paid less than their productivity. So I think it does reveal, these interesting aspects to the market. It sheds light on it in a whole new way. And actually, I also wanted to say that, Austin said, there's different reasons for monopsony power, absolutely, but it's kind of interesting that empirically, if you look across markets, for example, you find that there's a correlation between concentration and, measures of job differentiation, essentially, like across the territory. And essentially, part of it is driven by the fact that low-density areas, more rural areas, tend to have low concentration and kind of not a lot of choices for workers. So, if they have one job that they like, there's probably not some other, job that they can get as well. So, there are different reasons, and that can be important for some considerations, but empirically, the two seem to be, highly related. So if we're just looking for like a proxy, a way to say plausibly those markets are problematic, concentration can be useful because it's also correlated with the other thing.
Go ahead.
There's one thing about the pandemic, which is that, we can think of this as a form of fast technological change because we started to do things differently. We started to do things from home and things online, which we didn't do like that before. And I think much of what we've seen since the 80s is, of course, the digital age, fast technological change. And so it's just an acceleration of that process that's going on. So over the 4 decades before the pandemic, what we saw was not only did wages fall, but you would expect with an upward sloping labor supply curve that also labor participation fell. And it did. Not for women because there was the structural change, but since the mid-90s, even women have had falling labor force participation. What do we see in the pandemic? The Great Resignation. It's been the biggest decline in labor force participation since we have numbers. And I think it's an illustration, and by the way, falling real wages. Wages have gone up in nominal terms, but with high inflation, real wages have fallen. So it's, I think, stressing again, the same thing is going on probably a little bit faster because the technological change is faster. Faster decline in wages and faster decline in labor force participation.
I'm not sure it declined. I think EPOP, employment population, has gone up. I mean, since the trough of the pandemic. And then a lot of people are quitting for other jobs. So actually, I think what this speaks to in part is that there's high labor market tightness. Like the number of jobs relative to the number of applicants. And right now, maybe competition in the labor market is a little bit better than usual, for that reason. So the situation is good for workers, they shop around. That's kind of what you would expect.
The thing is, there's kind of a weird component which I think combines both of these insights, which seem like they're contradicting each other, but I haven't been able to resolve. If you just take loosely real output for the U.S. from pre-pandemic to now, it's up. Real output's up 4 or 5%, and the labor force number of workers is still below by 1% what it was before the pandemic. So real productivity is up 4 or 5%, and real wages are down.
Right.
So something's weird. Something didn't work, and it what? Profits are up. So then it's like, is it? It just feels like a super tight labor market, but how tight could it be if real wages are going down while productivity is going up? I don't know how to.
One of the things about the tight labor market is really measured in terms of unemployment, but not in terms of labor force participation. And that's where, of course, there's a lot of people switching, and that a lot more people are just out of the labor market that even don't bother looking for jobs anymore because the wages are lower. But at the same time, those who are looking get the jobs faster, and that reduces the tightness. So it increases the tightness.
And I agree with Austin about the gradual, or I guess sudden change to remote working that should reduce the concentration of labor markets, but only some labor markets. And there is an unfortunate aspect to this, which is that it's the higher paying occupations where people can stay home and work. And so there'll be more competition for those people, assuming it doesn't go overseas, right? Yes. Their wages will go up, but the low income people, the people who have to work, at restaurants or as orderlies in hospitals and all the rest, and some high income people like doctors, they can't really do much remote work. Those people will be hurt. So there'll be an increase in income inequality even greater than what we have now.
I wrote a little thing at the beginning of the pandemic, at the outset, that was very much in the spirit of antitrust. My great fear was we already had this increasing concentration, increasing corporate profits before COVID, and it had felt like all the small firms are dying and the big firms are going to survive, and so the profit's just going to go up even more. And I was trying to wrap my head around why is the stock market going up? The day they announced that 20 million people lost their jobs in a month, the stock market went up. And I thought it was some fundamental thing like business dynamism is going to die. We're going to kill all the small firms, and so the large firms are going to make more profit, and that's why the value went up. That hasn't aged that well, because actually it's been an unbelievable flowering of new firm creation. those trends of down and down have definitely reversed during COVID. Hopefully it lasts. Maybe it's just temporary. But there's been a whole lot of new small firms born in the last 2 years, which might make us less concentrated. I don't know.
So one other, my last question before we sort of open it up to the audience. AAG Cantor talked a little bit about, during his speech, how they are focusing more on litigation and also on labor markets. They've now filed a number of cases on this topic, and 2 of those went to trial this month, and both of them resulted in acquittals last week. So I wondered if any of you guys wanted to sort of offer some thoughts about why it is that juries or courts seem to be a little bit more resistant to these types of cases.
Oh, no. I was going to say Eric would know, but then
He wants the economist to talk.
You guys will just have to speculate. I'll internally evaluate.
You'll scream. What do you think?
Well, I really don't know, apart from the fact that it seems very trivial that since this is new to everybody, the judges, the jury, it's perhaps not completely clear like what's going on. And so, it might have been dismissed for that reason, but that's, again, sheer speculation. And I know we talked earlier about the role of experts. Who knows, they came up with some fancy models and the jury didn't get anything and they're like, oh, it must be wrong. Right, so no idea. That's sheer speculation on my part.
Great, I know, let's go Dina, because I know she hasn't answered asked a question yet.
Hi, I'm Dina Kalai. Excellent topic. I'm not an expert in it, but I can't think of a topic that touches almost everybody, right? Most people even either have a job or want to have one. We can't talk litigation, so let's talk policy. I just had a thought while listening to you. So perfect competition, right, usually is defined as full and symmetric information on both sides, and I think labor markets are an example of where there's definitely, we don't have that, because usually employees, don't share what they're making, either because they don't want to or because maybe they're afraid of, maybe they're not allowed to under their contract with their employer. On the other hand, according to NPR, there's now a trend actually of people revealing how much they're making, and I wonder if policies that would protect such acts, right, or would promote that disclosure by employees, wouldn't that be a way to make the labor market more pro-competitive because there'll be more information?
In fact, the state of Colorado, on that logic, makes the employers, I don't know if it's on job scores or what, they have to.
Wage range.
Yeah, you have to put the wage range of here's what people who are doing this job, what they actually are paid, and it's on the grounds you're describing.
Yeah, you have to know that only about a third of jobs or so say how much they pay when they advertise online. So that's like really sorely missing. Although there's other ways like Glassdoor where you can kind of go and look, but of course it just increases those search costs, like we call them, or frictions. It just makes the whole process more difficult. And I do want to add that along those lines, but that's a little bit different. First of all, we don't have enough research about how much that would improve matters, but it's certainly an idea that is worth thinking about more. But what there is a little bit more evidence on is the disclosure of your salary history. And that's, again, it relates to information bargaining power, that the employer asks you, how much were you making before? And then they can kind of tailor that. And so it seems like jurisdictions, states that adopted a ban on those practices saw, some differentially wage increases for people who are usually less well paid, like women, for example, or minorities. So there's 3-4 papers that seem to show similar things. So that's an interesting, thing to think about along those lines.
Yeah, just quickly, there have been a number of laws like the Colorado law that they're called wage transparency laws, and people have studied them. But the world's a complicated place, and it's not clear that these laws actually do what people want them to do. So on the one hand, the idea was, as people were saying, if the workers know what everybody else is paying, that they can bargain for a higher wage, and in a way, the advantage of the employer, which is confidentiality of what it can pay people, is lost, so they can get higher wages. On the other hand, though, if wage information is public, it'll be easier for employers to engage in parallel wage setting because they know what their competitors are doing. And there is a lot of parallel wage setting. There's some interesting new papers about this. And parallel wage setting is not technically illegal, but it can result in wages that are higher than, lower than what the competitive wage would be. And I believe there are a couple of papers that actually show that the wage transparency laws have not actually resulted in higher wages. But I think people are still doing
Yeah, it's
this
still
work.
in process.
In process.
The biggest problem is the amount of variation in wages that's due to unobservable characteristics. And so even if you make it public, we know that more than 2/3 of wage variation is due to we don't know what. It's not education, it's not the job you're doing, it's we don't know what. And so that's not going to help.
Okay, I have a very short question for the economists. If we assume that there's search frictions and asymmetric information and that's causing a markdown, do we know if exercise of market power on top of that would be a convex kind of effect or a concave kind of effect? Because if you came in asking for an injunction or damages or anything, I think it would matter what we thought the cumulative effect of all of the pieces were.
I think that's a great point. I mean, that's a more sophisticated version of my thing of, are we thinking through when we do this, the interaction of the price side and the wage side? If you add market, I don't know. Do you have an intuition?
You did some search, Miles.
It's going to go either way.
Anything can happen.
Totally.
My question is, given the importance of the issue, in fact, the Department of Treasury released a report recently talking about how lack of labor market competition is lowering wages. What is the low-hanging fruit that antitrust can work on? And a separate question is, what's happening outside of the U.S. on this front?
It feels like the lowest hanging fruit, like I say, is specific behaviors where you don't have to get into a discussion about some rule of reason discussion. Oh, is this good? Is this bad? If it's, we want to ban non-competes. Look, here's they signed a rule that nobody can go from one fast food firm to the other in a way that's understandable. I feel like that's the entree into the topic. Once we get to the more subtle, I consider more subtle space of let's treat in a merger discussion the labor market concentration the way we treat product market differentiation and concentration through the merger guidelines. That one feels like it's not, that's kind of high-hanging fruit. That's a little harder.
So actually, I think the DOJ is already doing the low-hanging fruit, which is not non-competes, but similar, but no poach. Actually, that
No
makes
poach,
a difference,
yeah, right.
because it's so no poach and wage fixing are per se illegal. And there's a case right now, U.S. versus Manahay, about Maine in the home healthcare industry about that, and that's like really the obvious thing, lowest hanging fruit. You don't need to prove any. I mean, no, you need to prove things, but you don't need to prove effects beyond the behavior. And then the second thing is mergers. I don't think it's that ambiguous at all. I mean, that's just my view. I think, based on my work with Herb Hovenkamp, and we've been looking at the history of, antitrust law and antitrust enforcement, the basic principle, that has emerged is that you don't do balancing, okay? So you're looking at competition in some market, and you're looking, is there a serious threat that there's going to be anti-competitive effects in this market? Meaning, if you're looking at the labor market, is that market? If the answer is yes, we're done. We don't need to worry about, but this other market, this and that, unless it would benefit the same workers, maybe then. But otherwise, That's it. And I understand that, as economists, we could think about the broader picture, but as far as enforcement, it's just unrealistic to go chase that, like second, third order effect on some other market, and it would allow for, we already say there might be not enough enforcement. If you allow parties to go there and use these indirect arguments, but there's this balancing consideration, we're never going to get anywhere as far as enforcement. And again, that hasn't been the jurisprudence. We have to look at one market. And maybe, Eric can.
Yeah, I agree. Obviously no poaching agreements, but mergers, all that I'm advocating is that antitrust law be used on both sides of the market in the same way. So we have a system for reviewing mergers. It's historically just looked at their effect on product markets. I've heard no good reason why they shouldn't also look at labor markets. If there is such a reason or a theory, someone should, publish it, come out with it. I haven't heard anybody explain why there should be a much higher effective barrier in one market than in the other.
Alden.
Oh, thanks, Leah. One question is policy instrument. Is antitrust the right instrument? Recently, a lot of states have passed amendments and upped their statutes, unfair competition statutes, dealing with things such as non-competes and so on. And how do you look at the reasonableness of a non-compete? Of course, there may be specialized non-compete, high scientific workers who might have some trade secret information. There might be some justification for limited non-competes, which there wouldn't be for the lower wage workers. But more generally, it's faster. Often these statutes can be applied more quickly at state level. There's a chance for experimentation. Antitrust suits, even seemingly straightforward ones, take time. And the problem with non-competes, unlike no poach agreements, which are horizontal agreements, non-competes are much more difficult. They're unless you can show some conscious parallelism plus, those are unilateral agreements. And under federal antitrust law, it's may be difficult to win a case like that, but it may be very much easier and faster under state unfair competition laws. Just wonder about reactions.
Yeah, I mean, there have always been state unfair competition laws which to greater or lesser degrees mirror U.S. Antitrust law. In recent years, a number of states have passed very simple statutes that say a non-compete is not enforceable. Usually there's a wage threshold if the person is being paid less than the median wage or something like that. Those could very well be sensible statutes. As a lot of people know, in California, non-competes are completely forbidden. It doesn't seem to have hurt the state. This has been true for more than 100 years. But the broader question is that I definitely do not think that antitrust law, even if applied to labor markets, would be a sufficient device for addressing these problems. A lot of these problems, they're very deep and complicated. The search frictions are very significant. There may be legal ways for addressing them, but a lot more thought has to be put into that.
Just noting on Alden's point, two of the states who have brought the most of these are Illinois and Washington State, and they have brought them under their mini FTC acts.
Yeah.
Go ahead.
Yes, thanks for a really interesting discussion. That was a really great panel. I wanted to push the panel a little bit on the extent to which we might think that rising levels of labour market concentration are responsible for wage stagnation or inequality, or the stuff that Jan presented. And I ask that because, as far as I can tell, the evidence is that we've established that there is labour market power, but not that it's grown over time. And in this month's American Economic Review, there's a paper that says because concentration in labour markets at a local level has in fact been falling over time, that the concentration effects are that it has pushed up labour's share of income by 4 percentage points relative to what otherwise might have happened. So does the panel find that result believable on its surface? Do you think it's plausible?
I'm going to jump in ahead of Jana because she has a very good answer to that. But I know which paper you referred to. I think there's a lot of debate. Let me tell you what I find, what we find with my co-authors, is that labor market power, monopsony power exists. It's sizable, but it hasn't changed much. And different work, Joanna finds it's increasing, these find that it's decreasing, and there's now debate about what happens over time. What we find is that the effect, indirect effect on wages from output market power is increasing over time. And so basically, wage stagnation is composed of these two effects, but the share that's coming from this indirect effect is becoming bigger and bigger. We find it 60+%. And so both are there, both need to be kind of addressed, but over time, since the 80s, the trend is basically an increase in this indirect effect from output market power.
So yes, there's still some debate about the exact kind of change in labor market concentration over time, but I think it's fair to say that when you look at the body of literature, there is no evidence that it's strongly increased over time. So from that perspective, I think it's still like in process. That's not really the way to think about it. And to that, I'd say two things. Again, there is labor market power, and we should address it, whether it's from concentration or not. But also, I do want to note another thing is that over time, as some have mentioned, there has been a decline in other types of worker power, in particular unionization, which has been advanced in other literature as a cause of wage decline. But of course, one way to think about it is also through worker bargaining power. And for example, the literature, there are several papers that show that the impact of concentration on wages, so how much having higher concentration tends to lower wages, this is blunted in the presence of higher unionization. So while the concentration might have been somewhat similar, there are other factors out there that make the effect, for example, of a given level, and that's only one of the mechanisms, but mean that for that a given level of concentration could have more adverse effects than before, for example, because unionization is lower, or because we have more non-competes. That would concentration is one thing, but if you have non-competes, it's as if you're increasing concentration because you're diminishing the number of employers that you could potentially go to. So I think the literature is still in progress. It's a complicated story about which bits how in terms of explaining the trend. But I would still come down to the conclusion that it's reasonable to strengthen labor antitrust enforcement, but even if we don't fully understand the decomposition of the wage stagnation trend, where exactly each part is coming from.
Yeah, and look, Joanna's research has shown some of the biggest concentrations are in rural areas. Over many decades in the U.S., rurals shrunk. So at some aggregate level, I wouldn't be surprised to find if the total amount, the weighted average is going the other way toward less concentration just from people moving to cities. But it's still, as she said, that still wouldn't be a reason not to enforce antitrust. It would just be an interesting fact that it's been the opposite of contributing to income inequality.
Yeah, I want to push a bit the assumption that workers are really similar to consumers, because I can think of many instances in which this is not true. It might be that some live on other financial resources, or even compare retired people to people who are currently working, or people who do not buy similar goods. And assuming that this is true, and we cannot assume that a worker is necessarily, every user is a worker, and we cannot compare, how do we really balance? I mean, we want to care about workers and we want to have a framework, but how do we put that in practice?
Well, I'm not in favor of balancing. Just to be clear, antitrust law doesn't balance when there's a when there's a challenge against something that a firm does. You usually, let's say it's brought by a consumer, you usually just look at the effect of what the firm did in the market in which the consumer is participating, the product market. If it's brought by the worker, you usually just look at what the firm is doing in the labor market. And under antitrust law, you typically ignore what's going on in the other markets, partly because it's just too complicated. So there's usually not going to be any balancing issue, and it's not any different. Your question's not any different from asking, how do you address a merger between two conglomerates which sell into lots of different consumer markets? Well, that you either, you could balance, or you could just look at, one market and just have a rule that if competition goes down in one market, you just block the merger. There are various ways of doing it, but I'm not, I don't think that antitrust authorities or courts should kind of do a welfare balancing effect on the two. When I said earlier that workers and consumers are the same people, I didn't mean that literally. I meant that, the subtext here is about the consumer welfare standard that some people think, means that antitrust law is just supposed to be focused on prices. It doesn't make any sense under the law. It doesn't make any sense as a normative matter, because we're just talking about the impact of certain business practices on people generally. The impact is negative. We want to stop it, and that's all that antitrust law does when the problem comes from collusive behavior or anti-competitive behavior.
And I would just say, I can see the legal argument that maybe the law says we should not balance one market against another. That doesn't make economic sense to me. And even if you looked within workers, if I told you this merger is going to lead them to close down plants, Boeing is going to merge with somebody and they're going to close down plants in Seattle, but they're going to expand the plants in South Carolina, you kind of know they ought, if you're going to make some statement about are workers better off or worse off, you can't really have a standard that there can't be a single market where workers were worse off. If you apply that standard, you will end up blocking mergers that would be efficient.
Okay.
So I think there's.
But it's important to note that it has to be a reduction in employment that comes from reductions in competition. So if the reduction in employment is merely efficiency, like let's say we don't need 2 accounting departments, that's not what we're talking about.
Well, but let me give you an example from the product market. It is, I think, an accurate description of how the law works that in the 2 satellite TV companies tried to merge. And one of the issues was that there are a bunch of tiny, tiny markets where there is no cable. So it would literally be a merger to monopoly of the 2 satellite firms. And there's no way the normal thing, if an airline has this problem, they'd be like, look, we'll divest these routes and then it won't block our merger. But there's no way to divest it for a satellite because it's just beaming down on the thing. That was blocked. The merger was blocked partly on the grounds that here are sub-markets. There's no balancing allowed. The fact that in Presque Isle, Maine, it would be a merger to monopoly, we can't let you merge, even if it would bring technological benefits to Chicago, New York, Los Angeles, and in some sense 320 million people would benefit. The fact that there were 50,000 people who wouldn't, the law set it up that they can't allow the merger for that reason. But we shouldn't be satisfied by that, because in some sense that's a messed up criteria. That's all I'm saying.
Your beef is with antitrust law generally.
Yeah,
it's not about labor markets versus product markets.
I once helped at the
but the
advised
problem,
on a thing at DOJ, and they said the lawyers at DOJ said the problem is the lawyers say to the economists, this is against the law, and the economists say that's not against the law, and they say yes it is, that is against the law. And then the economists say, that's a stupid law. Yes, that is part of the
conversation goes both ways, because the economists say, we've got this model, you have to look at every effect all over the world. Sure, it'll take a few months and whatever, but that's the right way to do it, because you want to know the entire impact. And then we say to the economists, okay, we'll do the analysis. And then they say, oh, well, we don't have the data.
Yeah.
Well, but I do think that this speaks to what should be the presumption about mergers. Should we generally assume that there's efficiency? And I know that Nancy Rose there is working on a thorough lit review of that, and I think it matters Because,
does.
you know, what's the burden
Does.
of proof?
Yes.
You know, how likely is it that your example would come to be, that we are really foregoing a big efficiency because we're looking at this tiny market that was adversely impacted?
Let's go here and then here.
Something? Oh,
No, you're on.
thanks. Thank you for a fascinating panel. This is a question mostly directed to Jan, but obviously open to hear from others. The graph that you showed with that fork between productivity and wage stagnation around 1980, I recalled and I checked and confirmed that globalization also took a turn around then. Mid-70s, I think globalization export as a fraction of GDP was around 10%, and now it's closer to 30%. And we know where a lot of that export is coming from, low-wage countries like China, like India, Bangladesh, et cetera. So how much could that be part of the story where that increase in productivity, you know, is happening through technological change and maybe even more diligent workforce at a much lower wage, and that puts pressure on low-skilled wages in the US, in Europe, and other places?
I mean, first of all, I mean, of course, the economist's favorite globalization experiment is the China shock, the WTO entry of China in 2001, which is also part of that. I think of globalization as a form of technological change, because if we ship stuff from Vermont to Alabama, that's national trade. But if someone buys bread from Luxembourg to France walking, that's international trade. And so, of course, what is globalization? It's faster trade, it's transmission of information, it's being able to do things that you couldn't do before with very distant production factors. But that's technological change in a different or the same form as it is nationally, right? Because if
Isn't his question is more like, let's say all that happened, it was all the same technology, but just there's some country that has lower wages.
Sure,
it's
but
not really, it's just lower wages. It's not.
But if that
technological
firm can hire workers with lower wages, it's making higher profits. Why doesn't another competing firm come in and sell that same product produced with these lower wages as well, because they can do it too, at a lower price? And so that's what I mean by it's another incarnation of technological change. It basically it saves the cost of labor, but that's what robots do. Robots are labor-saving technology. And globalization, I think of mainly as labor-saving technology. But if you have competition in the output market, you should see a decline in prices relative to the cost. So that's why we look at markups. That's why we don't look at price levels. We look at prices relative to cost. And I don't think that's different, but it's a robot or something that's produced in China.
It's also relevant, not 100% relevant because there are indirect effects, but you see these same patterns in non-tradables, you know, service sector industries in the U.S. So you wouldn't necessarily think that globalization would be doing this for real estate agents for, you know, increasing the profit share of domestic-only services companies.
That was a question.
We're going here first, and then we'll go to Matt.
Okay. So this is a little bit related actually to this discussion. So I wasn't here at the beginning, but I want to dig into a few definitions and a few very basic legal issues. One is sort of worker definition. So these days, you know, outsourcing is one thing, meaning, okay, you know, you're doing something, but actually it's like 3 levels down in some supply chain or just some delegation. You know, Facebook moderation is done by Accenture. You know, so in other words, it's not your employees and gig workers. So just where is the line between a worker and just somebody with a contract of some sort? And then whether the person is defined as a worker or not, you know, what happens to basic contract enforcement when it pits weak against strong? And there is a concept, again, because my head is really in basic law enforcement, there is a thing called wage theft, meaning you just didn't pay what you said you were going to pay. It's not like reaching into the pocket like in the street, but it's the same effect. The person has, in California right now, takes 3 years to get a hearing on just basic violation of wage contract. So all the empirical work, exactly what is it measuring, who you define as worker, all these details. One more point, mandatory arbitration. Again, it's in the basics of the law. Can you have a legal option against, as a customer or as an employee, and we're working on employee here, against any form of a problem, whether it's some other law, discrimination or whatever other law, when you had to sign a mandatory arbitration. And Concepcion decision has made that, has banned even situations where in state law it was unconscionable to have arbitration clauses in labor contracts, and that didn't come up. I mean, that's at the very basic level of whether, we're just talking about nexus of contracts or an employment relations, or exactly what it is the object of the study.
Well, there's some legal questions there, so let me try. So wage theft is a serious problem. It's not something that antitrust law addresses. Other laws address it, more or less badly, but it is a serious problem. The arbitration issue is very interesting. It seems that firms use arbitration, mandatory arbitration in the sense you don't have to. It's not mandatory in the sense you don't have to buy the goods, but if you buy them, you have to agree to the arbitration clause. For a while, people thought that workers and consumers could bring antitrust cases in court despite the existence of these clauses, but the Supreme Court has held otherwise. And this, I think, has undermined antitrust enforcement for both private antitrust enforcement, both by consumers and by workers. I think that has been an unfortunate series of cases. And then finally, on the employee, so the distinction that the law makes is between employees and independent contractors. And this is a distinction that is quite fascinating, actually, and I think economists should write more about it. But basically, roughly the rule is that you're more likely to be considered an employee the more control the buyer of labor has over you. And otherwise, you're an independent contractor. So I think everybody knows this has come up with the ride-sharing platforms quite a bit. And the distinction, is very important, because if you think of drivers as employees, they can form unions. If you think that they're independent contractors, if they try to form a union, they've violated the antitrust laws because they've created, they're colluding. It's a conspiracy to collude. So it's very important to get this distinction right. There's a lot of litigation and policy debate about it. It is related to antitrust law, but the relationship is so complicated, I think I'll save it for another time.
I just want to add that from an economics perspective, you could see many of those things as other ways to cut wages. So, the wage theft is obvious, but for example, the worker definition, we know empirically that outsourced workers tend to be paid less, so that's another way to cut wages. And the mandatory arbitration, in expectation, if you're going to be in a dispute with the employer, you would get potentially lower, amounts of money out of this, so it's another way to cut wages. So all of those can be seen as, certainly as a way to exercise monopsony power on the employer side.
I was just going to make 2 points. One, all three things you mentioned there were mentioned in the Treasury report that Brooke was referring to as ways that have reduced workers' wages recently. And the House actually did pass a bill on mandatory arbitration, I want to say a month ago, and it did, in fact, include a repeal for American colors. It's probably not going to pass the Senate. I think we had Matt Solar.
Thanks. I've really enjoyed the panel, and I have a kind of legal question. So in 2019, there was a merger between two gold mining firms, Newmont and someone else, into a firm that was called Gold Mines. One of the first things that the combined firm did was they got rid of the union, effectively. And so I'm sort of interested in this question of whether activities by a firm whether activities by a firm as a result of a merger or in other contexts to restrain workers from organizing could be some sort of indicia of harm over market power. We've seen a substantial amount of new kind of prominent labor organizing, Amazon, Starbucks, Apple retail stores. And I sort of wonder how that links into antitrust, if it does at all. But I'm just kind of more specifically on labor organizing itself.
Right. Well, Joanna and I actually, we wrote a paper a while ago in which we advocated that unfair labor practices under the National Labor Relations Act would be considered anti-competitive actions under antitrust law if the firms have a lot of market power or the firm is very concentrated. That doesn't, I don't think that's the law now. No court has ever said that. And the courts like to bifurcate the two. You know, they don't like to, where you know, labor law occupies, you know, a certain range of behavior, they get nervous if somebody makes an antitrust claim. So there's a potential antitrust claim there. As far as I know, it hasn't been recognized. I think conceptually, these are just, you know, if these two firms merge for the purpose of eliminating a union so that the merged entity could suppress wages, I mean, it's certainly a violation of the spirit of both labor law and antitrust law.
Okay, but wait, unpack that part. I could see that it feels like it should be illegal under the you can't do these things to harm the unions. The economic case, though, I don't fully get the logic, because the premise of our thing is wages below marginal product, but the presence of the union organizing and the ability to force rent sharing says the wages are above the marginal product,
Not
not
necessarily.
below.
Not necessarily.
Or
I don't
could
think-
be above.
Right, but I don't
could
think-
be above. Rather, it's
I asked people like
the
Joanna,
logic.
there's
No,
no
but hold on.
evidence of that.
The logic of the fact that it is severed from marginal product kind of says that the economic logic. I guess I just don't understand what the economic logic.
So you have two mines that are close to each other in a remote part of the country.
Yes.
There's a little settlement nearby where workers live. The two mines compete for their labor by offering, you know, they compete a little bit, competing the wage up. Meanwhile, because the wage is still below marginal revenue product, and because working conditions are terrible, the workers form unions, and the unions help them negotiate for the wage and protect the wage and address wage theft and bad safety conditions and so forth. So, and this is hypothetical, I don't know the facts, but you can imagine that it would be in the rational self-interest of the shareholders of these mines to merge. Now, there are two reasons. They have more bargaining power vis-a-vis the workers if there's just one entity rather than two. And if, for whatever reason, the merged firm has more resources to undermine the unions, that would be an additional reason for them to do that.
But the question of the merits would be, is the merged entity able to drive the wage down below marginal product? That I can totally understand. I totally understand that.
We're starting from different...
But I thought Matt's question was, if you could show that the merged entity was trying to undermine organizing, is that sufficient to be a harm? But I think
when you say
just
harm,
that is not...
It's a legal harm, whether it causes harm. So it is.
Like I could describe an example where wage was above marginal product,
so you could imagine,
and then it wouldn't be.
Right. You could imagine a situation that even though there are two employers, the unions demand a wage that's above marginal revenue product.
Right.
And that now the employers merge into a single entity.
Yeah.
Now the union collapses, but the single entity is not going to pay them marginal revenue product either.
But
it's going to charge. It's going to pay them the monopoly wage.
Only if you describe the fact pattern in that way.
Okay.
Okay.
What's the other
So
one?
I could give you a fact pattern in which, let's say we have auto firms where they're making large rents. There's profit, whether because the product side market is, I'm pointing at Jan because I'm thinking about the product side. There are profits, there's rent sharing. The union says if you're making extra normal profits, you got to share it with the workers. There's a merger that doesn't give them the ability to, it eliminates rent sharing, but it doesn't give them monopsony power.
Even though there's
So-
just one firm?
Well,
competing
it's a
for-
world market. In
Well,
this
but
thing,
the-
it becomes,
but
is a
right,
world
but
market.
That was
Well,
asking
they're
about
merging.
Nevada, the middle of nowhere, right?
Yes, but the Nevada case, it feels like the most important fact in that is not about the union, it's about the remoteness. That's what I'm saying.
All right, I've been told to cut you all off. It is now time for drinks, so please thank our panel for a wonderful discussion.